and so sought to insulate the election process from the deleterious perils and malaise of opacity, corruption, crime, and malpractice. The antidote they prescribed was an electoral system founded on and infused with clearly defined core principles, including, in particular, free and fair elections that are conducted by an independent body, are transparent in character, and administered in an impartial, neutral, efficient, accurate, and accountable manner. This appeal, as were the proceedings giving rise to it, are a call to the judiciary to authoritatively pronounce on whether these constitutional principles are upheld and given effect to, or are violated and infringed by certain provisions of the Elections Act, and we'll refer to it as the Act from here on, and the regulations made thereunder, insofar as they relate to the results of presidential elections. It is a question of first importance that implicates this Court's understanding of electoral accountability, the sanctity of the vote, the giving effect to the will of the people in the manner of elections as its overall constitutional philosophy. The appeal arises from the judgment and decree of a three-judge bench of the High Court, that is the Justices Mchelule, Korir, and Muita, delivered on the 7th of April 2017. The judgment was rendered in a constitutional petition filed by Maina Kiai, Khalif Khalifa, and Tirop Kitur, that is the first, second, and third respondents, respectively, against the Independent Electoral and Boundaries Commission, the appellant, and the Attorney General, the fourth respondent. The petition was filed pursuant to Article 165, subsection 3D of the Constitution, and sought declarations regarding the constitutionality of provisions of the Act and the Elections General Regulations 2012, which we'll refer to as the regulations hereafter, which are specified below. The petition was brought against the appellant as the body charged under Article 88 of the Constitution with the responsibility of conducting and supervising free and fair elections in Kenya. For his part, the fourth respondent was sued in his capacity as the principal legal advisor to the government, who is also responsible for representing it in legal proceedings and for promoting, protecting, and upholding the rule of law and defending the public interest. The first, second, and third respondents prayed for the following reliefs in their petitions, and I quote: A declaratory order that sections 39, subsection 2 and 3 of the Elections Act 2011 are contrary to the provisions of Article 86 and 138, subsection 2 of the Constitution, and are therefore null and void. B, a declaratory order that regulations 83, subsection 2, 84, subsection 1, and 87, subsection 2 of the Elections General Regulations 2012 are unconstitutional and contrary to Articles 86B and C and 138(2) of the Constitution, and therefore null and void. C, a declaration that respective constituency returning officers are the persons responsible for the conduct and declaration of constituency presidential election results. D, a declaration that constituency presidential elections results, once declared and announced by respective constituency returning officers, are final results for the purposes of that election. And E, a declaration that constituency returning officers possess a fundamental and an inalienable mandate to announce and declare the final results of a presidential election at constituency level, and that such declaration is final and is not subject to alteration, confirmation, or adulteration by any person or authority other than an election court pursuant to Article 8.6 and 138(2) of the Constitution of Kenya. Close quotes. The appellant and the fourth respondent oppose the petition on the grounds that the High Court did not have jurisdiction to hear and determine the matter because the question raised therein related to presidential elections, which were exclusively reserved by the Constitution for the Supreme Court, that the issues raised in the petition were res judicata, having been raised and determined in the case of Raila Odinga and 2 others versus IBC and 3 others, and that in any event the impugned provisions of the Act and the regulations were not unconstitutional. Before the hearing of the petition, the fifth respondent, Katiba International, a legal non-governmental organization focusing on the implementation of the Constitution of Kenya, applied and were admitted to the petition as amicus curiae and permitted to make written and oral submissions on the dispute. The petition was subsequently determined on the basis of the pleadings on record, as well as written and oral submissions. Upon hearing the parties, the High Court held that it had jurisdiction to hear and determine the petition, and that the issues raised in the petition were not res judicata, and allowed the petition in the following terms. And I quote, A, it is declared that to the extent that Section 39(2) and 3 of the Elections Act provides that the presidential elections results declared by the constituency returning officers are provisional, it is contrary to Article 86 and 138(2) of the Constitution and is therefore null and void. B, it is declared that to the extent that Regulation 87(2)(c) of the Elections General Regulation 2012 provide that presidential election results declared by the constituency returning officer are provisional, it is contrary to Article 86 and 138(2) of the Constitution and is therefore null and void. C, it is declared that to the extent that Regulation 83(2) of the Elections General Regulations 2012 provides that presidential election results declared by the constituency returning officers are subject to confirmation by the Commission, it is contrary to Articles 86, 138(2) of the Constitution and is therefore null and void. D, it is declared that the presidential election results declared by the constituency returning officer are final in respect of the constituency and can only be questioned by the election court. And E, it is declared that to the extent that the first respondent interprets Section 39(2) and 3 of the Election Act and Regulations 83(2) and 87(2)(c) to mean that it can confirm, alter, vary, and or verify the presidential election results declared by the constituency returning officer, in particular constituency, it is contrary to Articles 86 and 138(2) of the Constitution and is therefore null and void. Close quotes. The appellate was aggrieved by the judgment and decree of the High Court and lodged in this court an appeal founded on 23 grounds, which ultimately they condensed into 4 broad grounds, contending that the High Court erred by A, misapprehending the law regarding the constitutional and statutory requirements for declaration of results of the presidential elections, B, declaring Sections 39(2) and 3 of the Act and Regulations 83(2) and 87(2), C, unconstitutional, null and void, C, holding that it had jurisdiction to hear and determine the petition, and
Apologize for that freeze of signal, but I think we have it back with sound. We'll take you back to the Court of Appeal.
Three issues, namely the difference between announcement and declaration of election results, the person responsible for declaration of the result in a presidential election, and the purpose and effect of sections 39(2) and 3 of the Act. On the first issue, Council submitted that to appreciate the meaning of and the difference between announcement and declaration of election results, the context in which the two terms are used in the Constitution and the Act must be appreciated. They contended that announcement of the election results as used in Article 86C of the Constitution and in the Act and regulations means making the results of an election publicly known. On the other hand, declaration, as defined in Black's Law Dictionary, 9th edition, means, quote, a formal, a proclamation, an announcement, especially one embodied in an instrument, close quotes. Relying on the judgment of the Supreme Court in Hassan Ali Joho and another versus Suleiman Said Shabal and two others, the appellant submitted that a declaration is a formal pronouncement in the election process by a person authorized either by the Constitution or the law to make the declaration, which pronouncement brings the electoral process to an end. Accordingly, it was contended that the appellant's chairperson, who is usually appointed via a Gazette notice to act as the returning officer in a presidential election, is responsible for declaring the results of that election. In the appellant's view, an announcement of election result merely publicizes without finality the result of a particular election, but the declaration of results has the effect of determining the outcome of an election and bringing the electoral process to an end. On the second issue, the appellant submitted that the Act empowers it to appoint returning officers to supervise the conduct of elections for various offices. The appellant further submitted that under Regulation 3(1), the constituency returning officer is appointed to supervise the conduct of elections for members of the National Assembly and the County Assembly, while the county returning officer is appointed under Regulation 3(4) to supervise elections of governor, senator, and woman representative. The appellant therefore contended that the return
All right, our apologies there, loss of picture, but I think we have it back, so let's head back to the Court of Appeal.
Presidential election, the returning officer is its chairperson. 138(3)(c) and 10, it was urged that the same vests a duty to declare the results of the presidential elections in the appellant and its chairperson. In the appellant's view, a correct reading of these provisions demonstrates that the constituency returning officer has no mandate to declare results of a presidential election. The appellant relied on Hassan Ali Joho and another versus Suleiman Said Shabal in support of the contention that it is only its chairperson who has the mandate to declare the result of the presidential election. Accordingly, in the appellant's view, the conclusion by the High Court that the results of the presidential election announced by the returning officer in the constituency are final amounts to extinguishing the constitutional mandate of the appellant and its chairperson. Turning to the third issue, the appellant urged that the Independent Review Commission, that is the Kregler Commission, appointed to investigate all aspects of the 2007 presidential elections in Kenya, recommended that election results be declared final only after proper scrutiny and verification. It submitted further that Article 138(3)(c), as read with Article 138(10), emanated from that recommendation, and that Section 39(2) and 3 of the Act and Regulation 83(2) were intended to give effect to those constitutional provisions. It was the appellant's further contention that the High Court erred by failing to consider and appreciate the purpose and effect of Sections 39(2) and 3 of the Act before holding that those provisions were unconstitutional. As regards the presidential election, it was the appellant's view that Article 138 is self-contained and that there is no need to look at any other provision of the Constitution. That article, it was submitted, does not apply to elections of any other office save the office of President, a distinction that the High Court failed to appreciate. Regarding Article 86, the appellant submitted that its purpose is to set out the constitutional principle that election results should be announced promptly, and that Article 138(2) does not provide for the manner of declaration of presidential results. The appellant maintained that in a presidential election, the only act that takes place at the polling station is counting and announcing of the results, with the verification and tallying being escalated upwards. Lastly, the appellant submitted that the constituency returning officer is not mandated to declare the results of the presidential election, that the High Court assigned to him a role not contemplated by the Constitution, and that upholding the High Court judgment would mean that in a presidential election there would be 290 returning officers, 290 declared results, and possibly 290 election petitions and 290 respondents, which would be impracticable and an absurdity. Moving on to the second ground, the appellant submitted that Article 138(3)(c) requires it to verify the count before declaring the result of the presidential election, and for that purpose, its chairman is required to tally and verify the count from all polling stations before declaring the result. In its view, the legal definition of the phrase "to verify" is, and I quote, "to prove to be, to confirm, establish the truth, or to authenticate," close quotes, and not to alter and or vary results as was interpreted by the High Court. It was the appellant's contention that ballot papers are election materials which must be accounted for, and that the confirmation, verification, and collation carried out by its chairperson is a control measure to ensure that what is received from the returning officer at the constituency tallying center, as provided under Article 86(b), is consistent with the election materials that were issued for purposes of conducting the election. According to the appellant, therefore, the collation, tallying, verification, and confirmation of presidential results is a purely mathematical exercise for the purposes of consolidating the results received from each returning officer, and that it is on that basis that the results are referred to as provisional. As regards the constituency returning officer, the appellant maintained that his role is to collate and publicly announce the results from each polling station in the constituency in a presidential election in line with Article 138(2), and to deliver it to its chairperson, the collated results, which he is in turn tallies and verifies in line with Article 138(3)(c) before declaring the result in accordance with Article 138(10). On the penultimate ground, the appellant submitted that under Article 163(3)(a), the Supreme Court has exclusive jurisdiction to hear and determine disputes relating to the election of the President. That jurisdiction, it was contended, was not shared with the High Court, and the High Court therefore erred in arrogating itself a jurisdiction that it did not have. In support of that submission, the appellant relied on the decisions of the Supreme Court in the matter of the principle of gender representation in the National Assembly and Senate, and Samuel Kamau Macharia versus Kenya Commercial Bank, and in the matter of the Independent Electoral Commission, and added that a presidential election involves a series of events and is not a one-off event. In its view, disputes relating to elections to the office of president are not only those that arise after the presidential results have been declared, but include those disputes that might arise before, during, and after the conduct of elections. The appellant also added that the High Court assumed jurisdiction over the matter because it erroneously found that the process of election of the president had not commenced, yet on 17th March 2017, by Gazette Notice number 2692, the appellant's chairperson had gazetted the commencement of the presidential election. On the last ground, the appellant urged that the issues raised in the petition were directly related to the issue which was raised, heard, and determined by the Supreme Court in Raila Odinga and 2 others versus IBC and 3 others. The appellant further contended that AFRICOG, in which the first respondent is a director, was a party to the petition. The appellant applied Okiya Mutata versus the Communications Authority of Kenya and submitted that a party ought to litigate in one suit all matters that belong to the subject in controversy, and that what the first, second, and third respondents were doing was litigating by installment. The appellant therefore urged us to find that the High Court erred by entertaining issues that were barred by res judicata. The 4th respondent, Professor Githu Muigai, Senior Counsel, appeared in person, assisted by Mr. Mutinda, and supported the appeal, though he elected not to address the issues of jurisdiction and res judicata, opting instead to adopt the submissions made by the appellant. The Attorney General began by submitting that the High Court erred by holding that Section 39(2) and 3 of the Act and regulations contravened Article 86 and 138 and were therefore unconstitutional. Focusing first on interpretation of the Constitution, he submitted that the local jurisprudence on interpretation of the Constitution had become uncertain because courts tended to make their determinations on the judicial philosophy of, quote, the best political outcome, close quotes. The Attorney General argued that such an approach was not a proper basis for constitutional interpretation, that a legitimate interpretation demanded fidelity to the Constitution, and that an illegitimate interpretation results in an illegitimate amendment of the Constitution. Citing Interpreting Constitutions, a comparative study by Professor Jeffrey Goldsworthy, the Attorney General argued that judges, unlike other political actors, should be constrained by the laws of interpretation. In his view, whilst both the literal meaning of the provision and the spirit of the Constitution ought to be considered, where the provision is clear and unambiguous, it was unnecessary to invoke the spirit of the Constitution. As far as he was concerned, there were no inconsistencies between Article 86 and 138 and Sections 39(2) and 3. It was urged that in interpreting the Constitution, the correct tools and techniques must be employed based on the honest, transparent, and rational reading of the constitutional text. On the authority of, in the matter of Zuma and 2 others, and the state, and the Attorney General, ex rel. McKinley versus the Commonwealth, and a scholarly text by Aaron Barak entitled Positive Interpretation in Law, it was submitted that the language of the text of the Constitution must be respected and were it to be ignored, the result would be divination rather than interpretation. Also cited was the case of Theophanes and Herald and Weekly Times and another to drive the point that it is not legitimate for the court to construe the Constitution by reference to political principles or theories not supported by the constitutional text. Furthermore, it was contended that broad, purposive, and normative interpretations should be limited to cases concerning human and family rights, so that in all other cases the court is called upon to do no more than construe the text of the concerned provision. In the Attorney General's view, the language of Article 138(3)(c) was plain in that a presidential election, after the counting of the votes at the polling station, only the appellant was empowered to tally and verify the count and declare the result. We were urged to err on the side of caution by finding that the chairperson of the appellant is the person authorized to conduct the presidential election, to verify the count, and to declare the final result, and that the High Court erred by holding that there was conflict and inconsistency between the constitutional and statutory provisions in question, when that was not the case. At best, he asserted, the alleged inconsistencies were illusionary, and that the High Court and that had the High Court employed the proper and literal interpretation of both Article 86 and 138, it would have concluded that there was no inconsistency between them and Section 39, 2 and 3 of the Act. Those provisions, he maintained, address sequential steps that explain a chain of events and are not unrelated episodic events, and further, that whilst voting in all elections is regulated by Article 86, announcement or declaration of the result of the presidential election is regulated by Article 138 and the Act. While admitting that there may be situations when context is important in interpreting a statutory and constitutional text, he nevertheless maintained that the underlying intent of the provision in question is what is important, and there must be a good reason why there is a clear distinction between presidential and other elections, although they are held on the same day. In his view, a presidential election, the whole country becomes one national constituency, and the returning officer for that purpose is the appellant's chairperson. Next, the Attorney General submitted that based on a harmonized reading of Article 86 and Article 138(3)(c), the Constitution prescribes systematic steps which must be accurate, verifiable, secure, accountable, and transparent, culminating in the declaration of final results of a presidential election by the appellant's chairperson. In adding that Article 138(3)(c) empowers the appellant, after the counting of the votes in the polling stations, to tally, verify the count, and declare the results. Relying on Ali Hassan Joho, the Attorney General submitted that the declaration of presidential results involves a plurality of election officers who are obliged to give returns of the results in prescribed forms, culminating in the issuance of a certificate by the chairperson of the appellant. He added that Form 38 is the instrument of final declaration in all other elective positions, which is issued to the successful candidate pursuant to the results announced by the returning officer. Regarding the successful candidate in the presidential election, the Attorney General contended that the certificate issued by the appellant's chairperson was the instrument of final declaration, and that it is only after issuance of the certificate that the computation of time for the filing of an election petition would start to run. Accordingly, contrary to the judgment of the High Court, the declaration by the returning officers at the constituency cannot be final as regards presidential elections. The Attorney General submitted further that to give effect to Article 86, which requires transparency and prompt announcement of election results, Parliament set up a mechanism under Section 39(2) and 3 of the Act for the announcement of results from polling stations, constituency tallying centres, county tallying centres, and the National Tallying Centre. He added that results declared by the constituency returning officer for the governor, senator, women representative, and president are provisional but final as regards the member of the National Assembly and the member of County Assembly. Similarly, in his view, results declared by the returning officer are final in respect of the governor, senator, and woman representative, but provisional in respect of the election of the president. As far as he was concerned, there was no tension between Regulation 83(2) and 3, as was held by the High Court. He submitted that Regulation 83(3) concerned the decision of the returning officer on the validity or otherwise of a ballot paper or vote, whereas Regulation 83(2) concerned the results of the presidential election as shown in Form 34, which are subject to confirmation by the appellant in terms of Article 138(3)(c). He concluded that the confirmation envisaged by Section 39(2) and 3 of the Act and Regulation 83(2) and 87(2)(c) is intended to give full effect to Articles 86 and 138(3)(c) and is therefore constitutional, contrary to the holding by the High Court. Opposing the appeal, the first, second, and third respondents, who are represented by Mr. Otieno, Professor Sihanya, and Mr. Oginga, learned counsel, submitted that in interpreting the Constitution, the courts must pay due regard to its values and adopt an interpretation that is both substantive and purposive, while bearing in mind the mischief that the Constitution sought to cure. While accepting that there were provisions of the Constitution best suited for literal interpretation, the said respondents contended that the provisions in issue were not of that kind because they were informed by the desire to ensure transparency at the lowest electoral units. On the authority of the advisory opinion of the Supreme Court in the matter of the Independent Electoral Commission, the trio submitted that the spirit and tenor of the Constitution must inform the process of interpretation, bearing in mind the ills that the Constitution set out to cure. Turning to the question of declaration of results, these respondents submitted that the results of a presidential election announced at the constituency were final and not subject to any changes or alterations except by the election court. In their view, by dint of Article 138(2), voting in the presidential election takes place at the constituency level, where each constituency is required to conduct and hold presidential elections. Under Article 86(b), they further urged polling takes place at the polling stations in the constituency, after which the results are counted, tabulated, and promptly announced by the presiding officer. Once announced, they contended, such results are final as regards the polling station to which they relate and are thereafter transmitted from the polling station to the returning officer. Article 86(c) then requires the results from different polling stations to be openly and accurately collated and promptly announced by the returning officers. In the view of these respondents, elections are held in each constituency, and in accordance with Article 89 of the Constitution, Kenya is divided into 290 constituencies. According to them, there is no distinction between presidential, and other elections. The polling station is manned by a presiding officer who, at the end of the day, counts the votes cast and announces the results, which are then passed on to the returning officer. Once this is done, the appellant is obliged to tally the results, which can only be done by the returning officer, who is part and parcel of the appellant. They further submitted that the appellant is a body corporate. As a body corporate, operates through its officers, called returning officers, and donates to them powers to conduct elections. They added that the locality where the elections are held infuses transparency and accountability to the election process as required by Article 85 of the Constitution, and that at the constituency level, once the results are declared, candidates are obliged to sign declaration forms. Having made such declarations, they submitted it was not open to any other entity elsewhere to alter those results. To do so, they contended, would not only be an absurdity, but would undermine the transparency and integrity of the electoral process. Regarding Article 138.10, these respondents contended that there is a difference between results and result, and that the article provides for declaration of the result of the presidential election, which they interpreted to mean a final outcome, regarding which it is the function of the appellant's chairperson to declare. In declaring the result under that article, they urged the appellant's chairperson does not give the number of votes obtained by the various presidential candidates. On the other hand, they contended results means the total aggregate votes received by each candidate whose announcement is made by the returning officer and precedes the declaration of the election result. Making out their case why the chairperson of the appellant has no mandate to alter the announced results, the three respondents argued that the election materials containing the returns of the elections are retained at the constituency level, and none is delivered to the appellant's headquarters so as to form the basis of comparison and confirmation of results announced by the constituency returning officer. In the view of these respondents, to the extent that counting and tabulation of the votes takes place at the polling station, confirmation of the results can only take place at that level because no recount or retallying can take place at the national level in the absence of the necessary election materials. To purport to recount and verify all votes cast in all polling stations at the appellant's national tallying center would, in the view of the three respondents, be impractical, slow, and in utter violation of Article 86, which obliges the appellant to ensure that whatever voting method is adopted is simple, accurate, verifiable, secure, accountable, and transparent, and also in violation of the constitutional value and principle of prompt announcement of results. To the three respondents, finalizing the results at the polling station and the constituency is consistent with the constitutional principle of devolution under Article 10, and that it is transparent, constitutional, and in the public interest to finalize results at the polling station and the constituency. If it was the intention of the Constitution that the appellant should at the National Tallying Centre confirm or alter the announced results, they maintained, it would have provided so in express terms. Turning to the jurisdiction of the High Court to hear and determine the petition, the three respondents submitted that the High Court properly exercised its jurisdiction under Article 165(3) D1 of the Constitution, which confers on it jurisdiction to hear any question on the interpretation of the Constitution, including determination of whether any law is inconsistent with the Constitution. It was their position that the petition did not challenge the election of a presidential elect and therefore could not have been filed in the Supreme Court. Lastly, on whether the petition was res judicata, the three respondents submitted that issues raised in the petition had never been litigated and determined by a court of competent jurisdiction, and they, as parties, had not previously litigated upon the matter before any other court. It was their submission that the High Court was moved for the very first time in the petition to pronounce itself on the constitutionality or otherwise of the impugned provisions of the Act and regulations, and that Raila Odinga and two others versus IEBC and two others did not raise the same issues, as the petition and the parties therein were different from those in the petition. Accordingly, we were urged to find that res judicata could not be raised against the petition. Taking their turn, learned counsel for the amicus curiae, Ms. Nkonge and Mr. Waikwa, urged the appellants concerned regarding reconciliation of electoral materials at the Constitution and national level were taken care of by the provisions of the law, because once the votes are ascertained at the constituency level, the chairperson of the appellant will declare the result and issue a certificate, thereby bringing the presidential election to an end. Central to the petition, they contended, was the integrity of the electoral process. In the view of the amicus, the real issue was not about reconciliation of electoral materials at the constituency and national levels, but the certainty of the votes cast. They maintained that in the event of errors, it was not the province of the appellant's chairperson to make corrections, but rather of the election court. For good measure, they added that the law provided sufficient safeguards against human error in the electoral system. The amicus shared the view of the first, second, and third respondents that the appellant's chairperson or its officers cannot, under the guise of confirming, altering at the national tallying center the results declared at the constituency by the returning officer, relying on Hassan Ali Joho versus Suleiman Said Shabal and George Mike Wanjohi versus Stephen Kariuki. The amicus submitted that Articles 86 and 138.2 were clear and unequivocal, and that they did not render themselves to any other interpretation except literal. Turning to the jurisdiction, the amicus submitted that the questions presented in the petition and the relief sought therein directly engaged the jurisdiction of the High Court under Article 165.3 D 1 and 2. It was further contended that the subject matter of the petition was not the validity of the presidential election, but the consistency of a law or regulation with the Constitution. In the view of this party, the jurisdiction of the High Court to determine the consistency of a law with the Constitution was original and unfettered, and could only be exercised by the Supreme Court at first instance where, in the course of determining the validity of a presidential election, a question of constitutionality of a law was introduced and required to be determined by the Supreme Court to comprehensively dispose of the question of validity of a presidential election. It was further contended that even if the Supreme Court had jurisdiction to resolve the issue, that jurisdiction was shared with the High Court, and judicial prudence dictated that the High Court should be accorded the first chance to determine the questions presented in the petition. Lastly, on this issue, the amicus submitted that jurisdiction arises at the time of the institution of the suit and is not lost because of subsequent intervening events. such as the declaration of commencement of election of the President. As regards res judicata, the amicus submitted that the petition was a matter of public interest which should not be defeated by the principles of res judicata. Finally, we heard Mr. Orengo as Senior Counsel, Dr. Otiende, and Mr. Mwangi for the sixth respondent. It bears pointing out that this respondent did not participate in the petition before the High Court, but instead applied and joined the proceedings of this court with the consent of all the other parties. The sixth respondent took the view that to the extent that the appellant claimed that Section 39.2 and 3 of the Act and Regulations 83.2 and 87.2c empowered it to confirm, alter, vary, or verify the presidential election results declared by the constituency returning officer, these provisions were inconsistent with Article 86 and 138.2 of the Constitution. It was further submitted that under Article 86b, it was the duty of the presiding officer to count ballots, verify, and announce results at the polling station, whereas under Article 86c, it is the duty of the returning officer to verify, tally, and announce the results at the constituency level. The mandate of the appellant's chairperson, it was urged, is to collate results received from the returning officers countrywide and declare the same as required by Article 183.3. The sixth respondent therefore concluded that verification takes place only at the polling stations, that verification of the results cannot be conducted by any other person, and that only verification that the appellant's chairperson can undertake is that provided by Article 138.4. The sixth respondent disagreed with the Attorney General that Article 138 of the Constitution is self-contained, contending that the election of the President, like any other election, must comply with the general principles set out in Article 81 and be conducted generally in accordance with the Constitution. On jurisdiction, the sixth respondent submitted that there was no election, the validity of which was under challenge in terms of Article 140 of the Constitution. It contended that the petition before the High Court did not raise any question relating to the validity of the election of the President held in 2013, and that at the time it was filed, there was no President-elect as contemplated by Article 140. It was further urged that the restriction of the High Court's jurisdiction under Article 166(5)(a) must be understood within the confines of an election whose validity is challenged in terms of Article 140. In the opinion of the sixth respondent, not every dispute in a presidential election is a dispute about the election of the President. Lastly, on res judicata, the sixth respondent submitted that issues in the petition before the High Court and those in Raila Odinga versus the IABC were distinct and separate, and that the Supreme Court did not deliver any judgment on the merit on the issues raised by the first, second, and third respondents in the petition. In addition, the sixth respondent added the parties litigating in the petitions and before the Supreme Court were not litigating or suing under the same name or title. Having carefully considered the record, the respective submissions by learned counsel, and the authorities cited, we are of the view that there are three issues arise for our determination in this appeal. Namely, A, whether the High Court had jurisdiction to hear and determine the petition. B, whether the matters raised in the petition were res judicata. And C, whether sections 39.2 and 3 of the Act and the regulations 83.2 and 87.2c are unconstitutional, null and void, to the extent of that inconsistency. We remind ourselves that this is a first appeal, where our duty, as spelled out in Rule 29 of the Court of Appeal Rules 2010, is to re-evaluate or reanalyze the evidence exhaustively and to draw our inferences and make our own independent conclusions. As we do so, we pay due respect to the findings